Welcome to Pennsylvania's pre-service DVD for guardian ad litems. The reason that we're bringing this DVD to you is to assist new guardian ad litems in learning about the very important practice in the dependency system. The purpose of the DVD is to give you a snapshot of Pennsylvania's dependency system. It should be used in conjunction with other resources and, of course, continuing education when possible. The way that this DVD is laid out is to show you a snapshot of each type of hearing in which you would practice in the dependency system. There's the shelter hearing, the adjudication hearing, the dispositional hearing, and the permanency review hearing. In order to meet the CAPTA requirements, after the completion of this DVD, you should sign an affidavit being provided to you with this packet and provide that to the President Judge of your county. In addition to this DVD, there are other resources that you should utilize in your practice in dependency court. First of all, there's the Judicial Bench Book. A copy and a link is attached to this DVD. Make sure you take a look at that. This is the book that judges use, and it lays out best practices in Pennsylvania. A guardian ad litem should be comfortable with child development. The resource companion to the Pennsylvania Bench Book is a great resource for you to read about developmental issues with children. Child development, how to talk to youth, and grief and loss are all extremely important qualities that a guardian ad litem must master. Again, I would refer you to the resource companion of the Pennsylvania Bench Book for assistance with those matters. There are many legal resources that you can reference in addition to this DVD to assist you in your practice. All are linked right from this DVD. One is the Judicial Bench Book. This is a great resource written by judges in Pennsylvania for judges in Pennsylvania that outline the best practices. Make sure that you are very familiar with the juvenile court procedures, and also utilize the Office of Children and Families in the court's website. This is a great resource. For example, they have courtroom scenes that you can use with your clients that are age appropriate to show them where they'll sit, where the judge will be. This can really help with communication when preparing your client for courtroom time.
As you proceed through this process, you will learn more than you can possibly imagine. And it is your responsibility and obligation to represent your client, the children who are before us today and in the future. They are the most vulnerable population in Pennsylvania. In 1875, the church elders in New York found Mary Ellen in a flea-infested, urine-stained bed. They brought a case before the court in New York and asked that she be removed from her parents. The court turned them down. They said there was no law on the books which would allow the court to remove property, meaning the children, from their parents. Undeterred, the church elders filed a request under the cruelty to animals law. The child was removed from her home, and I will say thrived from there forward. That was the beginning in 1875 of the movement for child protective services. New York passed the first law in the country in 1875. In 1975, the state of Pennsylvania passed their first Child Protective Services Act, and that is what has developed as a body of law. You are one of the representatives of the children to take that law.
Children and Families in the Courts is an office that was created by the Supreme Court of Pennsylvania in 2006 to really help support local dependency court judges and child welfare administrators and Pennsylvania's dependency system overall to enhance the practice that was happening for abused and neglected children in our state. If you're watching this DVD, I'm very excited for you because you're coming into the dependency system in a time in Pennsylvania that is extremely exciting. We have so many judges involved, so many child welfare administrators involved in enhancing the practices that are occurring for abused and neglected children, and they're all being strongly supported by the Supreme Court of Pennsylvania. So we're very excited that you're watching this video. And I'm personally very excited about it because this DVD is really the end result of a priority that was set by the State Roundtable. And you probably throughout the DVD are going to hear a little bit about the State Roundtable. But that's a group led by our Supreme Court Justice Max Baer that sets the priorities for enhancing our dependency practice here in Pennsylvania. And one of the very first decisions that group made was that we really needed to provide support and additional education to the attorneys who are practicing in these courtrooms. So from that conversation, this DVD has been developed. I'm also especially excited if you're watching this DVD, that means that you have been selected to practice in your local dependency courtroom. What that also means is that your local judge has identified you as being one of the finest, potentially finest attorneys in the county, because representing children and representing parents in dependency matters is an awesome responsibility. But clearly your judge is seeing you as a person, as a professional attorney who is up to the challenge, and we're excited that you're joining the ranks of the wonderful professionals in Pennsylvania who represent children and who represent parents.
I wanted to talk to you today more holistically. It's fashionable and appropriate to look at child welfare from the eyes of the child. But I want to talk to you about looking at this subject from the eyes of the person on their deathbed, because what occurs during youth actually impacts, ripples through all of life. So we have two people in my construct. One is the individual who's lived the successful life, and he's on his deathbed and he thinks about his wife or husband of 40 years, his children, his grandchildren, his many friends, his many accomplishments professionally, personally, and the like. And while he obviously would rather not be there, he's satisfied with a job well done over all those years. Across the proverbial railroad tracks, we have another individual. And he can't quite believe what occurred some way, somehow throughout his life. He thinks back on the children he fathered but never knew, the women that he slept with but never loved, the transient housing, the time in and out of jail, in and out of drug rehab, and the entire litany. My suggestion to you is that there is a point in all of our lives, a fork in our roads. One road leads to the successful man, the other road leads to the unsuccessful man. And you, believe it or not, as child advocates, can be instrumental in children traveling the successful road, the road that leads to a life well led, rather than the road of despair and dysfunction and ultimate dissatisfaction with and the true tragedy of looking back on it all and saying, how did I waste my life? So unnecessary, and you can have a difference in it, as difficult as that may be to believe philosophically. So let's talk about that for a second. As I said, I think there's a proverbial fork in the road. I think the fork in the road oftentimes is in the courtroom where you're going to be functioning. And I think the default road, somewhat despairingly, is the road to dysfunction. Now, why is that? Why is the default road to dysfunction? I think the reason is that it's easier. It's the path of less resistance. What's the easiest thing to do? Not go to school, not do your homework, not brush your teeth, not go to church on Sunday, sleep through it, and the like. So left to their own devices, the 5-year-old, the 6-year-old, the 7-year-old, the 10-year-old is not going to do those things. They're going to run with the gang and not go to bed on time, not get up on time, not go to the dentist, on and on and on and on. So why don't most of us end up that way? The answer is really easy. It's because our parents will not allow it. They will fight us. They will control us. They will do what is necessary to force us down the successful road. And once we get used to it, once we get used to getting up and going to school, once we get used to doing our homework, once we get used to caring about our grades, the road becomes progressively easier. But it's not easy in the first step or 2 steps. And yet that is in the courtroom. Now, for the kids that you're about to go and represent, the challenge that you have is to make sure the children go to the right road. The fork, as I said, in the road is in that courtroom. And it matters what you do. It matters that you insist that siblings stay together. Insist on it. It matters that you insist that there be a family finding to find competent people in that family who love that child, love those children, and will parent them. It's important that you use the practices that you're being taught. We know they work. Specifically, family finding, to get the right people in the right room to raise the child, and family group decision making, so that that family can do all that they can to be successful with that child. It matters that that conference is successful and that those kids go home with their parents. And finally, it matters that once they go home, that we not just forget about it, but that we scrutinize them, we support that family, we provide services to that family, that we use our money so that that family can love their children and those children can be with those people that love them, rather than use our money for these children to drift from foster care to foster care, stranger care to stranger care, until we're all surprised when they aged out dysfunctional, so that the road they take is the road to success and not the road to failure. That's your challenge. That's what it matters. Every child matters. They all have a sacred life. They have a right to full potential, and it's up to you. It's up to you to try to develop that full potential. So good luck to you. Go out there. Use the practices that we've taught you. Use family finding. Use family group decision making. Don't let siblings get split. Demand services. Demand reviews. Advocate for your client's ultimate success. And I suggest to you that the lives you save, you will never know about, because that is not who makes news. And you will save a lot of lives. So my best to you, and go and make a difference. And when you're on your deathbed, you're not going to look back and say how much money you made, but you can look back and talk about the kids you saved.
There's a paradigm shift in Pennsylvania. Judges are now charged with ensuring that all parties understand that timely permanency is paramount in a child's life. And we want to achieve that permanency while reducing trauma as much as possible. Under the old system, the focus was on CYS. CYS created the family service plan. CYS told the family what they needed to do. And quite frankly, hoops were created. And the families had to jump through those hoops. The hoops were moving constantly. And it was really a matter of, could the family jump through the hoop and maybe at the end of that return their child? Now we know that that does not work. Our new system is family focused. We are strength based. We realize that every family has a strength. And if a family can be involved in creating their family service plan, they are much more likely to succeed. Quite frankly, who knows better what a family needs than the family? So with this paradigm shift, we have created a 4-prong mission statement. Prong 1 is to protect children. All children have the right to be protected from physical neglect and abuse, including sexual victimization and from emotional neglect and abuse. Prong 2 is to promote strong families. All children have the right to live in a strong family that provides a safe, nurturing, and healthy environment in which to be reared. All families are the primary source of the protection and nurturing of children. The third prong is to promote child well-being. All children have the right to be happy, thriving, self-actualized, educated, healthy, and content. To have the opportunity to reach their full potential as individuals, capable of healthy relationships and productive lives, and to have a fair chance in life with opportunities for healthy, balanced, and well-rounded development. And the fourth prong, perhaps the most important, is to provide timely permanency. All children have the right to live in a permanent family and to timely permanency decisions. These are critical to the health and welfare of dependent children. You may be asking yourself, why is the mission and guiding principle so important to what I'm actually doing in the courtroom? Well, there's a couple of reasons. First of all, look at who has endorsed the mission and guiding principles. The Supreme Court, the State Trial Judges Association, the Department of Public Welfare, among many others. So all of the stakeholders across Pennsylvania realize the importance of the mission and guiding principles. The second reason that it's important to your role in the courtroom is that we want to take these mission and guiding principles and practically apply them in the courtroom with court-tested techniques. Let me give you just a few examples. We want to talk about protecting children. When children are removed from their home, they experience great trauma. You should recognize this trauma, and it'll be discussed later in the DVD. So what can you do in the courtroom to reduce the trauma to protect the children that you represent? You want to be their voice in the courtroom. And as early as the shelter hearing, making the judge or hearing officer aware of the child's needs. It could be as simple as making sure that the child is being placed with family members or friends that they have a close relationship with. Or maybe it's making sure that that young child has his or her favorite teddy bear or blanket. Those types of small acts can greatly reduce the trauma that children experience and thereby protect them. We also want to promote strong families. As the guardian ad litem, you can recognize that the family has strengths. Look for the persons in that family and find out what are the strengths. How can we bring people together to help make decisions to benefit this child? One way to do that is through family group decision making. Family group decision making will be taught in more detail later in this DVD, but you should be open to bringing family members together and working towards resolving conflict so that the child can go to a stronger family sooner, thereby reducing their time in out-of-home placement. The third prong is to promote child well-being. We want to look at the whole child now, not just the tasks that parents have to complete in order for a child to be returned home. When we promote child well-being, one of the areas that we want to look at is visitation. Again, as early as the shelter hearing, visitation should be discussed. And quite frankly, visitation should be discussed at every proceeding throughout the case until the child is returned home. Questions that you might want to ask: why is the child not at home? Is the child being placed with relatives that they're close with and already have a relationship with? How often are they visiting with their parents? And if they're not placed with siblings, how often are they visiting with their siblings? We want visitation to have quantity, but also quality. Is supervised visitation really necessary? Is there a true safety threat if the child doesn't visit in a supervised setting? Look for creative ways so that the child can connect and remain bonded with that parent as often as possible and in as quality a setting as possible. Lastly, but perhaps most importantly, is to work on timely permanency. We want cases to be in front of the court as quickly as possible and as often as possible. This is where the art of lawyering comes in. Yes, we have an adversarial system, and sometimes it's necessary, but there are also times when you need to look for common ground. Look for motions court to move a case quicker, to improve visitation, for example. You don't always have to wait until a 6-month or a 3-month review to get your point to the judge. Make sure that all of the facts are being presented to the judge so that the judge can make timely decisions as well. It's very important that you take every step possible to move the case along towards timely permanency. This next segment is perhaps my favorite. This is the opportunity for you to hear from youth who have aged out of the system about what their guardian ad litem did well and what they did not do so well. This is the best way for you to learn how important communication with your client really is. So take heed to their advice.
My attorney, well, she knew my name, she knew all the things I was interested in. She'd always ask me about school, and she'd ask me about my music, which I was especially interested in. So she knew what was important to me.
There was nothing about my personal guardian ad litem that I really liked at all.
Some things that my attorney did that I liked was she always fought for what I wanted. Whatever I had told her, she would fight for and try to make sure that it would get done. The downfall was that she was only listening to me 15 minutes before my court hearing. So even though she was doing her job and what she was supposed to, she wasn't really getting to know me and knowing me as a person and any of my other interests to fully be aware of what I truly wanted and needed.
I didn't really have a lot of contact with my attorney to really know what I liked and what I didn't like. We just really met a few minutes before the court hearings, and I rarely ever attended a court hearing, so I think over the 10 years of being in care, I think I maybe have met her like 4 or 5 times.
She remembered things from time to time. Like, it wasn't just, oh, okay, this, like, she remembered certain things. She'd be like, oh, last time you were doing this, or the time before last you were doing this. So she listened and she kept tabs on me, which I thought was important.
He did not know who I was at all. If I saw him on the street, he wouldn't even recognize me. It's just like he's someone that he never met in his life before. I don't even think he would have known my name if it wasn't for his secretary whenever he called her to let her know I was there.
Some things that she could have done better to get to know me were to contact me in between my court hearings. Just a phone call would have been nice. I understand meeting can be difficult, so just a phone call would have been nice, and not just keeping it very business profession, like actually getting to know me as a person and not just a client or another case.
I met with him 10 minutes before we had a court hearing, and that was it. He would ask me about what I wanted and what I wanted to try to accomplish, but whenever I would tell him, he would tell me just to go along with what CYS was saying, just go with the flow and just cooperate pretty much.
Some things that I wish my attorney had asked me about would have to be how I truly felt, not just what I wanted, because that's what all she needed to tell the judge is what I wanted or what was best for me, but how I was feeling about everything. How I was feeling about everything, and if it was up to me, what would I do differently and what would I change and what I would plan for myself.
I would have liked some phone calls. I was about 100 miles away from my home county, so it was about a 3-hour drive to get to court hearings. So maybe every 6 months or even once a year, she could have come to pick me up and transport me, so we would have had that time to talk about things that were going on in my life, or even just phone calls, just every once in a while, just seeing how things were going. I didn't even know what her role was while I was in care. I learned this later after I aged out, and I think that would have been really nice to know what her job was and what she could do to help me, so I knew I had somebody to contact if I needed help.
If he would have done the things that my attorney did for me, he would have been an exceptional attorney ad litem, but he really didn't do anything for me. So if he could accomplish those things, he'd be great, but since he didn't, I had to go out of my way and get my own representation.
It would have been very helpful if she would have given me options or different ways of contacting her, whether they were by phone or email or even sending out a letter. My attorney explained everything briefly for me before we would walk into the courtroom, so it made it a little bit easier for me because she would sit me down and just say that my mother in her courts or the children and youth would talk, and then she was going to say something, and she would ask me if I wanted to talk, so then she would make time for me to talk. So she was very good with explaining what was going to happen. It was a brief introduction of what was going to happen, but she at least did explain it to me.
My attorney really didn't explain anything. we just kind of talked about what happened, and she caught up, and then we went in, and then court happened. I didn't really know what was going on. I mean, in the later years I caught on, but it would have helped when I was younger, because I would have liked to know what I was going in there for.
No, he didn't, but the kind of person that I am, I would find out ahead of time. I'd get on the internet, see what kind of courts were coming up and what I should expect.
She didn't explain anything. It was just really 5 to 10 minutes of like, what's going on? Is there anything I can do? That kind of stuff. It wasn't really, okay, we're going to go in and, you know, the judge is going to ask you some questions. If you don't feel comfortable, I can help you. It was nothing like that. It wasn't a very personal relationship. She was just another person, a part of the system that I didn't really know. She didn't really explain anything. It was just court was adjourned and I left with my foster parent or the driver that was taking me. There was no really explanation about what was going on, and I don't think that my feelings were really considered about how things were being decided about my life. They didn't really ask me.
No, my guardian ad litem did not explain to me after court what was going to happen next. She would just say, you did good, or, you know, well, court is in 6 months and I'll just see you then.
She really didn't explain a lot to me. I mean, we talked a little after court, just being like, are you okay, are you happy, and take care of that kind of stuff. A lot of explanations weren't really given.
I think it would have been very helpful to kind of know what the proceedings were about. Like, I know there's all these different hearings and everyone's different for a different reason. I think just an explanation of what was going on, what was the purpose of the meeting, and what I can do to advocate for myself would have been very helpful.
I think it would have been very helpful to understand why the judges made the decisions that they did, or any explanation on them, or to fully understand what was happening. Because to me, the only thing that I knew what was happening was I was going home, I was staying in the same placement, or I was moving, or whichever the decision was, I only knew that. And if you have any kind of explanation, it helps. If you don't like the decision, it helps understand it and for you to be able to adapt to whatever was made.
If I could give one piece of advice to the attorneys, it would be to know your child, know who they are, know what they look like, know what they're interested in, not just who they are on the piece of paper, who they actually are.
Don't just take the easy route and follow what CYS says and take the easy path, go off the path, and if it's a little bit rougher, then so be it. It's what they want. It'll make their life better.
My one piece of advice for guardian ad litems would be to stay in contact with your client. I know that they may have a lot of different clients and be juggling a lot of different things in their job, but they have a lot of control over what's going on, and can really be there to speak for us when we can't be. And I think you can't do that if you don't know what's going on with your client and what's affecting them. You can't help them if you only talk to them for 5 or 10 minutes before a hearing.
If I could give one piece of advice to the guardian ad litems, it would be to not treat your clients just as clients, but to try to get to know them as a person, and getting to know them as a person would be contacting them before court dates and truly listening to them, not just getting all the information that you need to walk into the courtroom, but getting extra information to make them feel human and important.
Pennsylvania is a hybrid state in the parlance of the literature on the representation of children. Some states in the nation are counsel states. Lawyers for children play the role of loyal and confidential advocate, traditionally associated with lawyering. Other states are more classic guardian ad litem best interest states. These lawyers serve as officers of the court, not bound by the child's confidences. or expressed wishes. Pennsylvania blends these two by statute and rule. And so we are indeed the hybrid of counsel and best interest guardian ad litem. And one can find guidance on this role in the Juvenile Act. We turn there for much of the direction and content of representation, along with some other key signposts like the American Bar Association Standards of Practice for Lawyers Who Represent Children in Abuse and Neglect Cases. The ABA standards give us these definitions: the child's attorney, bound by confidence and loyalty, advocating for what the child wants; best interest attorney, best interest guardian ad litem, not bound by the child's preferences, but driven by what the child needs, what's in her, quote, best interests. The guardian ad litem in Pennsylvania has this unique, important role of serving as the voice of the child in court. We're all required by law, Pennsylvania law, to be lawyers, and we bring the full range of our legal skills and training to this table of practice. We engage in motion practice, in investigative and discovery practice. We make argument. We also collaborate. In that way, it's different than some aspects of classic lawyering. We work with the other parties and their lawyers. We try to find the right answer for this child, to bring to the court what the child needs and wants in her life. I like to talk about 4 fundamental rules of child advocacy. The first, know the child. And so the ABA standards guide us. Establishing and maintaining a relationship with the child is the foundation of representation. One might imagine this is different from some forms of lawyering of business clients or even adult clients, where you might know your client, you may or may not like your client, but relationships a different business. But here in the representation of children, of course, they've been through rough times. Sometimes their very ability to trust has been compromised. The lawyer, the guardian ad litem in their life, we have a kind of a role to restore that ability, that opportunity to trust that's so important in being a child. Know the child. Know everything there is to know about the kid. Get a thickly detailed view of what this child wants and needs, likes and dislikes, her background, education record, behavior, needs, deficits, health issues, dental issues, behavioral health, any counseling history, what she likes in school, where she's been to school, where she wants to go. Continuity of school is very important for kids in the child welfare system because, of course, removal from family often means removal from school. There's very important law speaking to the stability of a child in her or his school of origin. Our third rule of child advocacy, know those who know. In child welfare work, children and youth have a sometimes large array of professionals who've been involved in their case. There's certainly all of the professionals and lay folks who were involved with their life before they came to the system, their teachers, their physicians, their family members, and others whom they trust, others who they've had some connection with, who know them. And then there's all these folks that we introduce them to when they come into the system. There's the foster parent, the foster care worker, perhaps a therapist or a set of therapists, the mobile therapist, wraparound therapist, developmental specialist, the person who's working with them and their parent, perhaps. Perhaps there are supervisors to all of those folks. There's the children and youth worker and the lawyer for the Children and Youth Agency. They often have information about the child, what she needs, what she's been through. There's the child's siblings. Siblings are so important in many ways. We'll look to their need to visit with each other, what opportunity we have, how to make visits happen. Siblings are also important in terms of the knowledge they bring about each other. Kids, they tell secrets amongst each other, and so you might have opportunity to talk to a child whom you represent and her siblings together. Sometimes, of course, we represent sibling groups, It's another part of the, in a sense, the standard of practice in Pennsylvania. The courts often invite a guardian ad litem to represent all of the siblings in a group, unless there's some conflict of interest between them, in which, of course, by law, they get separate representation. The fourth rule of child advocacy: let the court know what it needs to know, what it's important for the court to know. The court has a discrete and specific obligation in these proceedings. As we'll hear at the adjudicatory stage, it's to ask questions about whether the child has an able parent in their life, and then at disposition, what this child needs from their parent and from those others involved with the child. Your job is to help the court get to its decision. It has the most important role of all. The court's responsible for the care and well-being of the child to make decisions and orders. And the court looks to the guardian ad litem for part of the answer. Kids who've been involved in the child welfare system are often victims of abuse or neglect. Sometimes as well they have collateral experiences. They're secondary victims because of something that happened to one of their siblings. All the kids involved with the system need the opportunity to heal. They come to us for that opportunity. They come to us for that healing. Our job is to help that healing go forward with services, with supports, with family permanency, with people in their lives who can help change that sad story.
I've been asked to talk about what it means to be a guardian ad litem in the Commonwealth of Pennsylvania. And the task in Pennsylvania is twofold, which makes it somewhat difficult, because while we are serving as guardians of these children, we also have a responsibility to them as counsel. And sometimes that requires us to not only share with the court what our children want, but also what we view is best for them. And when those two things collide and they're different, it leaves us in a very difficult position. We have to remember that our court is asking from us something that they can't get from the advocacy system as it stands. If we only repeat back to the judge what he's already heard in the room, we're really not providing him with any additional information with which to make a decision. So our courts are asking of us as guardians to give the court more insight and more information than is available in the hearing room. And to do that with integrity and honesty to the court, it requires us to do more work behind the scenes. It doesn't help to just parrot what the caseworker thinks, or even what the child thinks, or even what we might think if there isn't any information to back it up. So we're in a very unique position in that we're the only person in the room that gets to give our opinion without being subject to cross-examination. And we're also not put under oath. So when the court asks us what we think, I would strongly encourage you to know that you have the information to back up that opinion and be coming to that opinion with as much evidence as you can. Additionally, we're given the opportunity to present evidence to make our case. It's not enough to simply go in and say, Johnny, the court wants to know what you want and you want to go home, and Judge, I think that's a good idea or it's not a good idea. You need to find the witnesses who can make the case. You have to remember that you are these children's only voice in the courtroom. And if Johnny wants to go home and there's a way to make that happen as safely as possible, it's your job to make that case. So find your witnesses, prep your witnesses, call them to court, subpoena if necessary, and put on the best case you can. Sometimes when we have to explain to children that they're not going to get what they most want, it's a tough thing, and it can be done artfully and gently, or it can be delivered harshly and sorry, you're not going to get what you want. And I would encourage you, as you go through this line of work, to find that artful middle, which is sharing with these kids what they need to know, making sure they can take ownership of the process, and hopefully encourage them to use their own voice in the court. Because while you're helpful, and we like to think that we're priceless in the courtroom, the best words come out of the mouths of our children. Because when it all comes down to it, it's about them. And we're best served when it's not happening to them, but it's happening with them, that they're part of this process. So I encourage you to find that artful balance, which will come the longer you do this work.
As the guardian ad litem, you are faced with the responsibility to present the evidence of this case. Not in the primary case, because the solicitor for the Office of Children and Youth will present the underlying evidence to establish the petition for an adjudication of dependency. Your job is to make sure that that evidence is accurate, presented fairly, and protects your client, the child, the vulnerable child. You must have an opportunity to present your evidence. Make sure that it is put on the record, that it is presented to the trial judge in an accurate, clear, and fair fashion. The evidence is only the facts that are prepared and presented to the case. Make sure you have an authentication of the medical records, that you know what the issues are, that if you want the mother to testify or the father to testify, that they are sworn in as witnesses and to present true and accurate testimony. We on the appellate court look at the case. We look at a cold record. The case that is presented to us has no new facts. The trial court makes a ruling on an adjudication of dependency abuse. Once the trial court makes that determination, there is a right of appeal. That's when we get involved. The Superior Court is an error-correcting court. We take a look at the record which has been prepared, and we look at the cold record. If you have not admitted your evidence, they do not come in. If you have not placed your objections on the record, it does not come in. You must give the trial court the opportunity to correct any errors. If you fail to do that and you fail to raise it before the court, typically that issue is waived. So take a look at your responsibilities, and as we go forward, present your facts, do your due diligence, do your homework. It is an awesome responsibility that you are charged with, but it is one that will forever change your life, because the work which you do increases the ability for a child to thrive and makes a long-term permanent plan. So on behalf of the Superior Court, the Appellate Court of Pennsylvania, we thank you in advance for your work. Looking forward to seeing you in court.
The next segment of this training is going to take you through practical tips for each type of hearing. We'll start at the shelter hearing, proceed to the adjudication and dispositional hearings, and end with the permanency review hearings. You're going to hear from advocates who have expertise at each one of these levels, giving you practical court-tested tips on how to enhance your performance. You're also going to hear from judges who are going to give you some do's and don'ts for the courtroom to help you with your practice.
Obviously, we encourage that all children attend the shelter care hearing. It's the first opportunity for you to meet your client. A lot of folks don't know how to make that happen, and the agency has custody of the child, so if you make a request to your agency, I have not yet had a case where they've refused to make a child available. Shelter care hearings are the first time that a child's going to see the court, and it's often a very frightening experience, and they often leave not knowing anything more than they came in with. So there's a number of things that I encourage you to ask for at the shelter care hearing. The orders that come out of a shelter care hearing are expected to contain findings. It is not enough for the shelter care order to simply state that shelter care is warranted and schedule the next hearing date. A shelter care order should set forth times for visitation between siblings and with the guardian from whom the children were removed. It should address whether the current placement is appropriate for the child, whether it's least restrictive, and why. If it will disrupt the child's school, it should address whether the child's continuing medical needs are being addressed, if there were current appointments that were scheduled that need to be maintained. That's something that should come up at a shelter care hearing. The most important thing you can do that you can take away from shelter is to make sure you ask questions. Even if you don't know the answer, and even if you know the caseworker is not going to know the answer, you still need to ask the question. Does the child have all of their things? Do they have the clothes that they need to be able to get to school? If the homecoming dance is coming up, do they have their dress and their shoes? When it comes to the visitation question, past practice has always been that when the child says to us, "When am I going to get to see mom?" we say to them, "Soon." And what soon sounds like to a child who's frightened and doesn't understand what's happening is never. And we need to remedy that. So instead of saying soon, you need to ask the court and make a proposed solution. Let it be Tuesday. Give them something that they can, concrete, that they can look at and know is going to happen, and it's something for them to look forward to. We all know that more frequent visitation with families encourages reunification to happen sooner. So take that opportunity at the shelter care hearing and ask the question. There's a lot of debate about supervised and unsupervised visitation, where visitation can happen, does it have to happen at the agency or not? This is a real opportunity to use your common sense and ask those questions. For example, a child that is removed from a home for home conditions doesn't necessarily warrant supervision if there were no safety concerns about the child and the parent. So that visitation might not need to be supervised. If it's not supervised, that parent might be able to see that child 2 or 3, 4 times a week, as opposed to once every 2 weeks for 2 hours. So although at a shelter hearing you don't have all the information that you could want, it doesn't mean that you can't ask questions and really put everybody thinking on their feet and come up with as good of a solution as you can pending the next hearing.
It's my privilege to talk to you as guardians ad litem and the importance of your role from a judicial perspective. From the moment you are appointed to represent a child, your focus should be upon developing the relationship with that child that you represent. And the first thing you should do is obtain all the information you can from the caseworker, that file, and from any references in that file to other individuals. The importance of the pre-hearing preparation cannot be overemphasized. If you have difficulty in obtaining information, do not be afraid to request that the judge become involved in requiring the release of information to you, because you cannot begin to effectively represent that child until you are first informed. Once you are informed with a record review, you should begin the development of the relationship with the child. That requires a meeting, many meetings in advance of the hearing where you will be representing that child's interest. You should be in touch with the caseworker at all times regarding if any possible change in the location for the child, and you should freely give your information to both the child and any foster parent or guardian responsible for that child. That means your name, your telephone number, your address, and also where you can be reached when that child may be available, which may mean evening work. That's part of the responsibility of a guardian ad litem. You should not be meeting the child for the first time in the few minutes before the hearing. That does not allow for the development of the relationship. When you come to court in representing the child and now you have the relationship and all the information, you should be an active participant in that entire process. Think about the questions you want to ask in advance by way of cross-examination. The worst thing you can do is say, no questions. I can't tell you the times I've been disappointed in hearing a witness present testimony and I anxiously await for that guardian ad litem to challenge areas of testimony and I get the response, no questions, Your Honor. That means you've not been prepared and are not ready to represent that child. After the hearing in the case, you must continue your representation. That's required by rules and it's required for effective representation. That means staying in touch with the caseworker, evaluating the progress towards the goals that have been set in the hearing. That's how you effectively represent the child. Do not be afraid to question processes that are followed by your individual counties. Don't accept the answer, well, that's the way we always do it. Because if we don't question the processes, there will never be effective change, and that's our responsibility. You must be sure that you keep the focus on the child and your responsibility for representing the interests of that child throughout the hearing. I fully recognize the difficulty this presents to active practitioners and appreciate your willingness to sacrifice on a professional level to represent children. You should take full advantage of all trainings that are offered through OCYF, become involved on a statewide basis in knowing others in your shoes in other counties, because we may learn best from others who are practicing in other areas of this Commonwealth. Stay up to date on all the current law that affects your area of work. I've provided you with the do's, what I expect of you, but I also want to just provide a very short list of don'ts. And really they are just the converse statement of some of the things I have been saying. The first should be very obvious to you. Don't get in this work for the money. We all know you are not well paid in terms of dollars, but I can't tell you the satisfaction that you will experience until you fully represent a child to the best of your ability and see the difference you can make in the life of a child. Another don't is don't wait for information to come to you. Rather, you be the proactive one, seeking the information, prodding the caseworker, prodding the parents, prodding the child, to make certain that all the plans that have been laid out in a plan are well on their way to completion well before the hearing that is scheduled, hopefully a minimum of 3 months from the last time you're in court. And that leads to another one. Don't just accept the fact that you are given a very short period of time in court to represent the interests of your child. Advocate for sufficient time for you to present your case, your evidence, and fully represent the child's interest. Do not regularly ask that the child be excused from the proceedings. That should be the exception rather than the rule. It's very important that the judge has an opportunity to see the individual child about whom everyone is talking and about whom decisions are made. That may require you to be a little innovative. Have your little tools with you for entertaining a preschool child, a school-age child, and even a recalcitrant teenager who really does not want to be present in the courtroom. I do not mind at all if there are crayons and paper, if there's just a pen and a pad, something for that child to be engaged in and maybe feeling a little more comfortable by looking like they're not fully involved, but they're listening to what's happening. I do not want to end on the don'ts, but rather go back to the do's. Everything that I have talked about, I hope will inspire you to form the relationship with the child that you represent. And thank you for the work that you do.
With respect to the guardian ad litems, the child advocate attorneys, they should talk to their young clients before they get to court. They should ask their client questions. They should make sure their client asks questions to promote their conversation before they get into court so that they don't have to stop in the middle of the court proceeding and say, let me talk to my client for a few minutes. Making the client feel stressed or confused or uncertain about what's going on, what questions they could or should ask. They should talk to their young client about the prospect of talking to the judge if they want to, that's an option for them. If a child wants to speak, they should be given the right to speak. Quite frankly, no matter how young or old they are. For me, as juvenile court judge, that's sometimes a game changer when I hear from the young client of the guardian ad litem. If I hear from a child, if you have trouble contacting the child, contact the OCY caseworker. If the caseworker, for some reason, is unable to be reached, contact the supervisor. Make sure you talk to your client before court. Make sure you ask them what they want to see happen in court. Ask them if they want to say something, what is it they want to say? They may have trouble with the way they want to say what they want to say. Without leading them or suggesting things to them, do a little practice Q&A to reduce the jitters and prepare them. If you can, bring them into the courtroom before court so that they can get a comfort level of what's going on. And I'm talking about kids as young as 4, 5, 6, however little they are, or even the oldest of teenagers, 16, 17, 18. They're all nervous. Start with that assumption. Explain to your clients who they're going to see in the courtroom. Explain the dynamic of the dependency proceeding. Who are the litigants? Who are you going to see? Who should you expect to see? What's going to unfold? What's going to happen? What are the possibilities of what are going to happen? This goes for the children and the parents. You need to give them an idea, a prediction, so to speak, without giving them a guarantee. Make sure you explain to your client each proceeding and the meaning of each proceeding and what's going to happen. Shelter care proceeding is very different than an adjudication and a disposition. And it's very important for a child or a parent to understand the nature of the proceedings and what could happen at each step. Ask your clients if they have questions. Many times, I know myself as an attorney, albeit now I'm a judge, but I remember quite well, I found myself often just talking to the witness. You have to remember to stop and ask them if they have questions. Be mindful that the judge may ask questions also, and you want to be prepared, not to look good, but to be representing your client as a professional, so that your client feels good and confident, and that all other parties have confidence in the other professionals in the system, and so that the judge sees that everybody is prepared and professional.
I'd like to talk to you now about the adjudication and disposition, key dimensions of the procedural history and life of this case in court. Unlike the shelter care hearing, which we've talked about, the adjudicatory hearing is asking that fundamental question, is the child without the proper parent? The shelter care asks a kind of emergent question, where's the child going to be tonight? The adjudicatory is a more intensive intrusion into the right of a parent to control their child, to have access, and to exclude other people from their child's life. And so it's a big deal from a constitutional perspective and from a practice perspective. The adjudicatory hearing asks the fundamental question, is the child dependent? Is the child without proper parental care and control? This is actually the language of the first of 10 possible grounds for the adjudication of dependency. These 10 grounds are articulated in the Juvenile Act and are set forth as pleadings in the dependent petition. And with the pleadings, the moving party, typically the Children and Youth Agency, is required to bring forth evidence in support of those pleadings or allegations. They really are like charges. And so the petition will carry a host, kind of litany of horribles sometimes. You're not going to see a lot of strengths in the document. It's intended to prove that the child has needs, and perhaps that the parent is not meeting those needs. The dependent question really gets back to parenting. Is there a proper parent in this child's life at the moment? It's not looking real far into the past. It's certainly not looking real far into the future. It's this present tense question, today and in the current space of time. Are this child's needs being met? The parent's not required to meet the maximum best level of care, right? We never empower government to require all parents to be everything for their kids. It's a minimum standard. This is clear in the statute as well as in the case law. Is the parent being responsive to the child's needs? Has the parent harmed the child? Is the parent able to prevent harm to the child? It's not about isolated incidents of neglect, but neglect is often a ground, a basis for an adjudication of dependency. Drug use, per se, is not ground for a finding. And so we talk about a hot screen. Very often in our work, parents are subjected to drug screens. More typically, that screening process happens downstream after the adjudication. And prior to that, of course, it's a search and seizure. But drug use can be persuasive. And certainly where the drug use is implicating parenting, where it's getting in the way of meeting this child's needs, well, it makes a big difference in the outcome of the adjudicatory hearing. Two important legal issues. The burden of proof is on the moving party, typically the county agency, to prove dependency by clear and convincing evidence. And the rules of evidence apply almost in their entirety. There are a couple of exceptions articulated in the statute and in the code, in the rules of evidence. But at the adjudicatory hearing, we have a fairly high level of procedural due process, protecting the right of the parent to control access to their child.
The number one rule is meet with your client before the proceeding. Please respect the wishes of the child, even if you don't agree with them. If your position as guardian ad litem as to what is in the best interest of the child is different from the child's wishes, make sure that you explain that to the child before the hearing. In other words, tell them what you're going to recommend to the court so that they don't feel blindsided or betrayed. Make sure that you encourage the child to participate in the court process and to speak up. It's really important for the judge to hear from the child's own lips, from the child's own mouth, what the child wants. And while the attorneys do a good job of explaining that, it really does make a difference in how I might decide the case or what emphasis I might place on what the child wants. And don't be convinced that because the child is a toddler, maybe 2 or 3 years old, that the child doesn't have something to say. They often have something to say, and it's often important. Have consideration for the feelings of the child and the bond and relationship that they have with their parent. This could be simply by stating, I recognize that this parent loves the child very much, but Judge, I need you to understand these things, and these are my recommendations. Although you're going to focus on what the child needs, make sure that you focus on what the child wants as well. Being in foster care and removed from the parents is a very traumatic event in a child's life. And so sometimes asking or requesting things that the child may want is really important in helping the child adjust to the traumatic event of out-of-home placement. Don't talk down to a child. Most children don't understand the word condescending, but believe me, they know it when they see it. They will feel belittled and betrayed if you talk down to them in a way that makes them feel that you don't acknowledge that they're smart, that they have a voice in the proceedings. Don't interject your personal values on this child and the child's family. While we may think that our lives are perfect and we do things a certain way, that's not what you're here to decide, and that's not what the court decides. The court has to decide whether the child can be safely returned to the care of the parents, even if you don't particularly like their lifestyle.
Guardians ad litem, what are some of the do's and don'ts that you should be thinking about when you're handling these cases? A few big areas. One big area is contact with the child. Some guardians simply talk to the child before hearing, and it's very important to expand that. Go to visit the child as much as you can, make as much contact with the child, see the child in different circumstances if you can, let the child know that they can contact you in between hearings, and keep an open line of communication with the child and develop a rapport with the child, not just representing what they've said or what you think should happen, but actually developing a rapport with them. What you really want to do is you want to be able to paint a picture for the judge in terms of how everything is going, not just come in with conclusions. You want to show the judge what's happening in this child's life, not just tell the judge. Some other do's and don'ts as a guardian are not to take reports at face value, not to discount what the child says, and to remember that your job is to give your opinion and your recommendation as to what you think is in the child's best interest, but also to represent to the court what the child wants, understanding that those two things can be different. Another important thing to do is when you're presenting to the court what the child's interest is or the child's wish is, it's important that you're ready to present evidence supportive of that wish of the child, not just to tell them what the child wants or to paraphrase it, but to present evidence supportive of that.
The disposition hearing addresses what happens next after this finding of adjudication. Unlike in the criminal context where sentencing might happen weeks or months after the adjudication of guilt or innocence, the adjudication of dependency is sometimes followed immediately in the same hearing by a first dispositional hearing. Why? Because we have to answer this fundamental question, where's the child going to be tonight? It's kind of live work. We need to know where that child's going tonight, where she's going to school tomorrow, who is caring for her today. And that's the fundamental question about disposition. The rules of evidence are looser. The statute is clear that all competent evidence whether or not admissible, all competent relevant evidence may be admitted to help the court make this dispositional finding. The standard is also clear. Preponderance of the evidence speaks to what the child needs. There's a little speed bump here. If the child's going to be removed from his or her parent's care, the moving party must make that finding by clear necessity. So we ask this basic question: is it clearly necessary to remove the child from his or her parent? Reasonable efforts is a phrase you'll hear often at both the adjudicatory and the dispositional hearing, and throughout the life of a child welfare case. The notion of reasonable efforts is given to us from the federal law. It's a condition of federal financing of these cases. And it asks, did government, did the state or county agency act reasonably in preventing the placement, in preventing the removal, in facilitating the return home, in working with the parent to avoid this placement? It's a very practical question. And so the advocate must ask, both the parent advocate and the child's advocate, is there some reasonable alternative? We all should be asking this question. From a strengths-based perspective, we want to know, is there some dimension of this family life that we can build on? The classic kind of situation is where housing is the issue. And so one might ask, can housing be provided in order to avoid the placement? Through the life of the case, the court and thus the advocates will be asking the reasonable efforts questions. Safety and permanency are two watchwords of the dispositional stage of a case. The very meaning of the business is about the safety of the child. At the core, that child has a legal right to be with a permanent family member. Typically, that's their birth parent or some other person who is legally responsible for them. But safety and permanency are the way to well-being. And that's our real objective, to raise children, to raise them into healthy adults. And so we need to be concerned with all the aspects of a child's well-being. This includes their education, their physical health, behavioral health, even their dental care. We want to know about after-school activities, and we want them involved. Kids in foster care, there's no reason they shouldn't be involved in their local scout troop, or after-school activity, or sports, or chess club at their grade school or high school. We ought to ask them what they want, because of course, just like your kid or mine, we want to make the experience of childhood as normal, as ordinary, and as child-specific as we can. We're representing the whole child as guardians ad litem, as lawyers for kids. However they come to us, we are responsible as a system for the whole of them. We're investing in their future. The work that we do for them today, they will be unpacking long after we're out of their lives. It's a weighty burden. It's an important job. We want it to be fun, encouraging, and delightful for you and for your child client.
And in your new role as a guardian ad litem, one of the tasks that you may be asked to assume will be the medical and educational decision maker for a child. One of the most important parts of that role will be to look at the issue of psychotropic medications that the child might already be on, or someone may be contemplating putting the child on those medications. Should the child be on a medication at all? Well, how can you decide that? You're the guardian ad litem, you're not a medical person. You should ask yourself first, if the child is displaying troubling behaviors, tantruming, hurting themselves or hurting someone else, or if they're depressed, what could be the reason for that? Well, we can assume a few things. We can assume that a child has experienced trauma if they've been removed from their home. So first, one should try all sorts of interventions that have nothing to do with chemicals. For example, one might look at whether the child is missing their parent, their mother and their father, their siblings, whether visits are not quite long enough, whether the visits really need to be supervised or not, whether that child needs some attention to their physical well-being. Are they eating well enough? Are they sleeping well enough? Is there a need for more exercise? Does that child need activities? What's happening with that child at school? Is it possible that the child is being bullied in any way? Is it possible that all the changes in that child's life have led to these behaviors? It's incredibly important to look at all the non-chemical interventions before you say to yourself, an assessment is necessary. If you determine that even after all these interventions, there still are troubling behaviors that cannot seem to be managed, then the next question is, okay, let's have an assessment. And an assessment may lead to a diagnosis. So it's important to recognize in your role as a guardian that it's not necessary for every child to have a mental health assessment. If they have this assessment and a diagnosis is made by the psychologist, the next question is how to intervene then. Again, the next question for you should be, it's not always medication that that child needs. Sometimes what that child needs is intensive therapy. Therapy is really the response for small children, teenagers, any child involved in the system. Medication, unfortunately, is quicker, it's easier, and it's much less expensive, and that often tends to be the recommendation. When a child is in your care as the guardian ad litem, you should then say to yourself, if this child is on medication, why is the child on the medication? Who prescribed it? How long has the child been on it? Is the child experiencing any side effects, weight loss, weight gain? Does the child have a flat affect, unable in any way to communicate effectively what it is that they need and they want? It's very important to see what type of effect they were expecting for the medication from the child, for the child. The next question really for you is, if this child's been on a medication for a long time, is it time to take the child off the medication? And if not, why not? Is that child on multiple medications? Take a look at all of those issues when you come to the court, because the court can order an additional assessment. The court can order that the issues of medication be studied. The court can order all sorts of interventions that may obviate the need for continued medication. You should know that in the nation, everyone is very concerned right now about the number of our children in care that are on medication. Estimates now are 75% of the children in out-of-home care are receiving psychotropic medications, mostly off-label use, and causing grave side effects for children. So when you are acting as the medical and the educational guardian for a child, make sure you understand all of these issues, because when you come into court, the judge is going to want to know.
Know the backstory of the child and the family. So often when we get into the courtroom, we begin with maybe what has brought the child into the dependency system. And that is an important part, obviously, to know. But so often that has had a backstory. It might be the life of the parent themselves. It might be events that have happened in the life of the child before the child even got into the dependency system. And so although it takes a little extra time, maybe as counsel, to learn the backstory, my experience has been that if you make yourself knowledgeable about that, often the solutions come from understanding the backstory. Know the value of the question, why? We describe a lot of behavior, we describe a lot of facts in the courtroom. We're a very fact-oriented system in dependency, but that isn't always the whole story. Asking the question, why would that happen? Why would a parent be addicted to drugs? Why would a parent move 10 times? Our presumptions may not always be accurate. Behavior, it doesn't change easily. We know that, even when it's for good. And so transforming behavior is what the dependency system is about. We have to be smart about the way we change behavior. So as a guardian, understanding motivational interviewing, understanding that people don't make change because we tell them they're bad. People don't make change because they already know they've done something wrong. They make change because of their will to do so. And so helping people find that answer and will is really a large role of everyone involved, and particularly the guardian, perhaps. Know and look for signs of grief and loss. Much of what we understood as being bad behavior of children or poor decision-making of parents is not necessarily that people want to act like that, but often their grief and loss unprocessed can bring about behavior that looks to us as if they don't care or they're not interested, when in fact they are really suffering from grief and loss that they have not processed. And so again, that ties in with the asking why. Is this about grief and loss? It ties in with the backstory. What has happened to them over a period of time that would bring about this type of situation, bringing them into the dependency system. Also helping the family unload all of their pain and grief, not just the child, but the family can really begin to strengthen everyone and promote the health of that family. Know that when you help the family, you help the children. Sometimes I think the guardian ad litem sees their role as just looking at the interest of the child, and certainly that's the primary interest. But there's no child that doesn't love their family. In my experience, even children who have been physically abused have a fondness and a love for their biological parents and want that relationship to be healthy. And so just taking care of the child's needs and not addressing the family's needs really doesn't promote the life of the child, who needs that bonding and needs as much health within that family as possible, even if it is from a placement in a distance. I think the guardian has a special role to be the mediator. There's no one that has as pure an interest in a dependency case, perhaps, other than the court, hopefully, but in terms of the litigants, than the guardian. The guardian has the interest of the child. And in the end, that's what we're all supposed to be there about. So the guardian really can fulfill a role of playing the mediator and bringing everyone back to what are we here about? And bringing all the stakeholders to the table. They have a great opportunity to think outside the box and be creative instead of people finding their adversarial advocacy and making sure that we all come back to the important question, but how will this help the child and how will this promote the family? Finally, in all of these tips, an overarching goal would be that to always speak the positive first. I think that strengthens the system, it strengthens the family, and it strengthens the child to know that there are strengths there to build on, that we're not just there to tell them what they're doing wrong. And always remember, when you help the family, you help the child.
I think one of the most important things you can remember about permanency hearings is the necessity to look to progress versus compliance. For years, hoops were set up and we judged cases and parents by how many hoops they jumped through. And unfortunately, there were times when more hoops got added to the end of the list. We're really trying to change the way that's done, and we're trying to look at the progress that folks are making towards the ultimate goal. So for example, we're asking the agency to give us articulable goals. So for example, go to AA. Well, the goal behind going to AA is to maintain a sober lifestyle. So if a parent can come in and prove to us that they're maintaining a sober lifestyle, does the fact that they actually went to the AA meeting matter as much? And it may not, depending on a particular case, but some may say the progress is more important than the actual compliance. So what we're finding is that a lot of caseworkers are drafting much more specific case plans to actually achieve the goals that we're seeking, which is, for example, not go to AA, but instead maintain a sober lifestyle. When you get to your permanency hearings, you really need to examine what the goal is, because the goal being go to parenting classes doesn't help us as much as this parent really needs to be educated about the developmental differences of her two children that might be 5 years apart in age. So her going to a parenting class that focuses on teenagers, while it would have satisfied her obligation to attend a parenting class, doesn't really achieve the goal, which is to educate her about what she needs to know to better be able to provide for her children. So progress versus compliance is one of the key takeaways in a permanency hearing. Another thing to look to at a permanency hearing is the court's going to be asking you whether the current placement needs to be continued. Is it time for this child to go home? If it's not time for this child to go home, have we exhausted all other efforts? Again, I encourage you to go out and find the people that can make your case. At this point, the case has been ongoing for at least 6 months. I'm certain your child has come up with an opinion or two Hopefully you've engaged with your client, you've met with your client, you know what they would like to see happen. And this is the time to make the case for that child to get what they want, assuming that can happen in a safe manner. So if the child wishes to return home, this is the time to make that case. If there are still nagging safety issues, have you proactively tried to address them? If a parent, for example, was asked to take anger management courses and they hadn't complied and completed them by the time of the permanency hearing, you need to ask the court if strict compliance is what our goal is, or is trying to get a child returned to their family who are trying and making progress in the plan. The effort to find family should never stop. We can never say we've looked everywhere and we've exhausted those efforts, so I encourage you to ask the question again at the permanency hearing. Hopefully you've done some of that investigation on your own and maybe you've identified some folks or the caseworker has brought new people before the court, but it's your role to reach out to them and call and ask if they're willing to be a resource for this child. It doesn't necessarily mean placement with them, but the more people that these children have that care about them and love them, the better off they're going to be in the long run. So again, permanency hearings are really about, there's status checks. Should we continue going down the course we're going, or do we change? And I encourage you to be able to answer that question before you even get there, because as you ask yourself that question, you're going to find gaps and you're going to see that you need more information, and hopefully you'll reach out, get that information, and be able to make the best case that you can at the permanency review.
Make sure that you're familiar with all the rules. There are a lot of needs that kids have. I want you to, one of the things, to find out what those needs are. A number of times as lawyers, we get caught up in what we know as a lawyer. So look out and reach out to others for additional training. Some other more experienced GALs, talk to them as well, so that you can understand the needs of your client based on their ages. Obviously, if you have a young child that's 2 or 3 versus one that's 14, 15, their needs and the things that they see are different. So expand your knowledge in regard to those areas as well. Maximize the child's participation in the decision-making process. Even on those occasions where you don't agree with the child, you still need to hear it, explain your thoughts and your view of the case, but they need to be involved so they can understand it. And normally what happens, if they understand exactly where you're coming from, it's easier to represent them in court, as well as easier for them to follow the recommendations of the judges as well. Make sure that you see your child in their context. They all have families, communities, different cultures that are there and involved with. So you want to see their worldview. A lot of times we get caught up in the adversarial role. Many times, that's ineffective and inefficient as well in regard to meeting your client's needs. So make sure that you collaborate with others in the courtroom as well. Don't be satisfied with the first impression of the child. Many times you have a child that you ask them a question, he gives you a one-word answer, or they're shy, they don't want to talk to you. Many times what they need is someone that they trust, someone that's going to be on their side. So take the time to get to know your client.
I'm very excited to have the privilege of speaking with GALs, or child advocates, depending on what county you're in, about the potential for collaboration between parent attorneys and GALs. In terms of how we can best work together, or some ways that we can work together, and some reasons to work together really, is number one, as child advocates, you have a duty to do your own independent investigation. In order to do a really adequate investigation and to find out all the information about your client and their history and their mental health history and their school history and their family history, all of that information is most likely going to be information that the parent can best provide. And as parent advocates, if we have good lines of communication, in most cases there's no reason why we cannot help you get that information. In order to facilitate reunification, it's going to be incredibly important that both children and parents receive appropriate services. And that's, one area where we really have the same agenda. We want the children and the parents to receive quality assessments, to really identify what the problems are, and to really receive high quality services that are actually going to alleviate those problems, fix those problems, so that this family can move forward and reunify if possible, right? We want to give them a fighting chance to reunify. Another reason that parent advocates and child advocates should collaborate is collaboration will lead to faster permanency outcomes. Why? Because we will be able to resolve issues of controversy faster, and we will only be truly litigating real issues. There's so many, the devil really is in the details in a lot of these cases, right? You'll find that if you're new GALs, or if you're veteran GALs, and then you know already that a lot of times things break down in between court hearings because the visitation instructions weren't detailed enough, or it wasn't clear who was going to make the referral by what date, and so the assessment didn't actually happen. And so there are a lot of delays in those types of logistics. And to the extent that parent advocates and child advocates can really talk through and come to agreements about what it is we want to see happen, we can join together then to ask for that, to make sure that those types of things are on the court order. Those types of things that a lot of them are going to be non-controversial. We may disagree over visitation, but there's a high likelihood that we'll be able to come to some type of negotiated agreement. Also, as a GAL, one of the first things that you will likely have to deal with is the trauma that your child client is facing. The trauma of having been in an abusive or neglectful situation, and potentially the trauma of having been removed. As we all know, removing a child from a home is itself traumatic, and oftentimes the removal may be to a stranger. In foster care, it might be removing a child in addition from their parents' custody, removing them from their siblings, from their school, from their neighborhood, from their friends, from their church. This really presents an opportunity. There are many things that the parent can do to help minimize the trauma to that child. For example, they can let the child advocate and the foster parent know what are the favorite things the child likes, what are the toys the child likes, how the child likes to be calmed down, what are the types of activities the child enjoys, can develop some relationship that is helpful, especially in the initial stages, to make sure that the removal is not as dramatic and traumatic to that child, and then also ongoing. As you can imagine, parents are going to worry about their children who are in placement. Even if it's a kinship placement, right? The child is not in their custody. They're going to worry about, what is that child thinking, doing? Are they happy? Are they crying? Are they safe? Are their, medical and mental health needs being met? And that's even more amplified if the child is in foster care with a stranger, and if the parent, doesn't know that foster parent, and, in some cases, may have not met that foster parent directly, or met them, just for a few minutes here and there at visits. So it's very scary for parents to think about and to worry about what's happening with their children. To the extent that GALs advocate strongly for their child clients while their clients are in care, it really alleviates the stress for parents and enables them to focus on their goals. Both parent advocates and child advocates have the goal of trying to place children when possible with family members. And here, parents are really in a position to identify family members who the child knows, or who the child may get along with, family members who are likely to be able to work within the parameters of the child welfare system. And sometimes, at the initial stage of removal, parents are really not in the mental frame to identify other caretakers. They're just simply stunned. And it takes them a little while to be able to focus on, okay, if my child can't be with me, who is the right person for my child? Who is the right person to be taking care of my child? Who in my family? So it may not come immediately upon removal, but it may come a little later, where parents are able to identify people who would be good family caretakers. One thing I want to stress is that, for the most part, even parents who have abused or neglected their children love their children deeply, want their children to thrive, want to get better, want to reunite with their children, want their children to be in safe placements, and have a lot of information to share, and also add value at every step of the process. So one of the most important things you can do as a GAL is to respect the parent, to allow them in the process, to hear what they have to say with an open mind, and to allow their value, to allow their input to matter. In most of these cases, the children will reunite with that parent. And it doesn't help the reunification if during the process we have so undermined that parent, their authority, their self-esteem, that it's difficult to go back to assuming the parental role. We want to be careful that we don't, through our own actions, somehow destroy something of value.
When I was new to the dependency system, I really didn't understand why I needed to know all of the kind of soft, feely, touchy stuff that the caseworkers do. After all, isn't it their job to understand the social work part of this? Well, what I learned was, in order to do my job well, I have to have a basic understanding of what the caseworkers do. For example, my husband, who's also an attorney, who does not normally do personal injury cases, received a case where he had a client that had a huge head trauma. He spent hours, if not days, researching about head trauma so that he could properly depose doctors. It's what we do in every other area of practice, so why not in the dependency system as well? So even though you need to be aware of the laws and the rules of procedure, you also need to be familiar with the practices and the guidelines that the caseworkers follow. Next, you're going to hear from Christy Stanek, who is really an expert in this area, as she guides you through safety threats and all of the paperwork and maze that caseworkers have to work on every day.
I'd like to talk to you today about some terms that you're going to hear in court. Safety assessment and planning, and family service plans. And prior to the bulletin on safety assessment, decisions were made very inconsistently across the Commonwealth by caseworkers. Oftentimes decisions were made based on perceptions, what that particular individual felt was appropriate and not appropriate, safe and not safe. And as you can imagine, there was inconsistencies across each county and across the state. So Pennsylvania recognized that and issued the Safety Assessment and Planning Bulletin. And what this did is brought consistency to decision making. Why is this important to you as a guardian ad litem? The importance to you is that every decision on whether or not a child should be placed is made based on the safety assessment. So as a guardian ad litem, when you're in court and you're representing your client, it's going to be important for you to ask to see the safety assessment prior to the hearing. Review the safety assessment. Look for things called threats. And what a threat is the caseworker's assessment of danger to the child. A threat ultimately equals an unsafe child if it cannot be controlled. Threats are serious, they're immediate, they're observable, they're out of control, involving a vulnerable child. So threats are something that cannot be controlled by any other mechanism. There's safety assessments that are standard across Pennsylvania that counties use, and when a caseworker completes the safety assessment, they'll indicate whether or not there's a threat to the child. Now, if there's a threat to the child, does that necessarily mean that the child has to be removed? The answer to that is no, and that's where the safety plan comes into place. So what you want to ask a caseworker prior to the hearing is to see and review the safety assessment. If you see a threat, you want to ask if that threat can be controlled with a safety plan. Why is that important? Because oftentimes across the Commonwealth, the agencies are still adapting to this new decision-making form. So it's your role as a guardian ad litem to make sure that your child has been assessed fairly, accurately by the agency who is doing those assessments. And by asking to see the safety assessments, by cross-examining on the safety assessment, and by asking if the plan would control the threat, ultimately what you will be doing is challenging whether or not that child needs to be in placement or can stay at home with an appropriate safety plan. Another critical element to safety assessment and safety planning are the protective capacities of the guardians, the parents caring for the child or children. It's very important that you ask about the protective capacities of the parent. Protective capacities are the natural ability for a parent to protect their child, often involving cognitive components, behavioral components, and emotional components. So what you want to look for are things like, is this individual bonded with the child? Do they have a positive regard for the child? Are they aligned with the child? Or are they aligned with the alleged perpetrator? These are critical questions for you to ask when looking at protective capacities, because protective capacities often give you an indication of whether or not the parent can protect the child in the home with a safety plan. The next term that I'd like to talk to you about is more traditional planning that has been around in Pennsylvania for quite a while, and it's what you're going to hear called the Family Service Plan. The Family Service Plan is the plan that is developed with the family to identify the areas that need to be resolved in order for the family to end their involvement with child welfare. Family service plans should always be developed with the family. No longer should we see cookie-cutter family service plans that spell out the same services for every family that comes through the door. Family service plans need to be individualized. Families are individuals that have individual needs, and there are individual resolutions to those issues going on within the family. So as you look at your family service plans, if you see things like, we'll attend psychological evaluation, we'll attend psychiatric evaluations, we'll attend drug and alcohol, we'll attend parenting classes, we'll attend in-home services. These are the types of cookie-cutter family service plans that we do not want to see. It does not individualize the plan, certainly doesn't give the family measurable goals to let them know when they have resolved the issues at hand. So it's critical when you look at family service plans to challenge what are the measurable goals in behavioral terms so that your client knows what they need to resolve. For example, if you're representing a child and they have drug and alcohol issues, what you would not want to see on a family service plan is that the child should attend drug and alcohol treatment and follow through with all recommendations. You would want to see something measurable, something behavioral, that the child would know what they need to do in order to get that resolved. So for example, you would want to see something along the lines of child being able to identify their triggers, that the child would identify the individuals that they use the drugs and alcohol with, and identify separate peers that they might be able to get involved with. You would want to see them actively participate with their groups at treatment. Rather than simply following all recommendations, you would want to see some specific behavioral recommendations that could be measured, so that when you go to court, that you could share with the judge that the child is hanging out with a new group of friends, that the child now understands that the triggers for them happen on Friday and Saturday night when their friends call, and now they have put a plan into place to address that. So you would want to see something behavioral, you would want to see something measurable, so that you and your child know when that issue is resolved.
Family finding is the opportunity for the agencies and all the stakeholders involved in the lives of children to make sure they have positive connections. Family finding is not so narrow to be just the opportunity to find a mom and a dad, or to find someone for the child to live with if they cannot be safely with their mom and dad. But it really is broader than that, and it's about finding connections, positive connections for children. And we know that the more positive connections a child has, the healthier their life they can live, to have that many supports and people caring for them and about them. So the role of a guardian ad litem really begins with asking that question: has there been a family finding done? And you might run into people who say, oh no, we have a mom and dad, we don't need family finding. We ask you to go beyond that. We ask you to go beyond and say, but who will be in this life of the child once dependency is over? And how do we build positive supports in the life of this child? So as guardian ad litem, you want to be asking the question, have we done it? And be persistent, because it is a best practice, and we know that there will be life beyond the dependency system for this child. So where will they have Christmas? And who will send them a birthday card? And who will care that they graduate from college? Will there be more than 2 people there? And so that's really the role of the guardian, is to trigger that and prompt that we build that for the child for beyond the years in the dependency system, or even the short time they're there.
It's interesting because so many people have said to me they have tried to define what is family. And you know what? Family is not for us to define. Family needs to be defined by the child. Who do they believe to be their family? By the child's parents. Who do they believe to be family? And part of the process can be saying things like, where did you spend last Christmas? Who was there with you? Tell me about an event in your life that you really had a good time and who was there. So again, it is not up to us in government to define family. As guardians, it is so important for you every time you meet with the caseworker to ask the question, have you found family? Have you found family? Asking it once is not enough. You should also be asking the child, do you have any family members that can be a resource? Do you have any family members that you spend time with? It is critical that children are kept with family whenever possible.
Family group decision making is maybe one of the most powerful tools that we have within the dependency system. It's more than just a process. It can be a philosophy and a way of life. It is a way to help families develop the ability to make decisions for themselves and to no longer be dependent on a system, that they feel empowered to make their own decisions, because safety for the child is best met by the families who know themselves better than anyone else knows them. So it may feel a little counterintuitive to have families in the dependency system that are there because they haven't made good decisions, or they haven't been able to keep a stable life. And it may seem counterintuitive to give the power back to them to make the decisions. But the opportunity is there for them to know themselves in a different way and to work together in a different way that could bring about a different result. And we know with family group decision making that that happens. And that's why it is one of the recognized best practices. Guardians ad litem can be involved with family group decision making in 2 ways. One would be in the fact that you actually ask, can we have a family group decision making in this family? Is this an appropriate time for a family group decision making? Again, front loading the system with this type of work so the guardian's role isn't necessarily a litigant in a courtroom. The second way would be if you are invited to a family group decision making, which is the only way attorneys can participate. It would be a very great honor to any guardian, because that means that you have been identified as a person that has a heart, hand, or mind on the life of that child to the degree that the family recognizes you as someone who could contribute to helping to find a way for this family to work together. So in either direction, you play a very, very important role with the promotion of family group decision making. And family group decision making is very, very important to the role of the guardian ad litem to make sure that that tool is used for this family, if at all possible, in creative ways. Very, very important to any child to maintain a level of contact with their parent even after they have been placed out of the home. Not just the parent, but the siblings as well. We know from all kinds of research that it is very important to the success of a child if they have continuing contact with their parent, even if the parent's incarcerated, even if the siblings are placed in a different home. Very, very important for that contact to continue. Otherwise, we're creating more trauma, more grief and loss with the child that interferes with any positive forward movement of the family. So making that visitation, one, common, and the guardian ad litem is playing that role, making sure how often will this child see their parent, and insisting on it if they really don't see the agency really coming to the table and providing it. We have minimum standards on the Department of Public Welfare. Nothing says that it can't be more than that. And so the role of the guardian ad litem would be maybe pricking the consciences of the court, of the caseworker, of the supervisors to ensure that the contact happens. And not just any kind of contact, but as natural contact as possible, so that the family is not in a sterile room, but is really looking at safety issues only. And if you can safely have visitation in someone's home, always the least restrictive alternative. So this family can feel like a family, even if they're not together, even if they have problems and things need to be worked through, they still have the benefit that they have each other, and they have the pieces of each other that are safe, that are loving, and promoted. And the guardian can play a very important role, and maybe even asking the child, who would you like to see? Who is important to you? Who listens to you? Visitation might not be the parent. It might be the grandmother. It might be the aunt. And you won't know that unless you ask the child. And that plays a very, very important role in that child's life and getting them through a very difficult time. It is important that visitation take place between siblings as well. And we've often found situations in our experience where it's just impossible for all 4 children to be in the same home. You also have different family members because you might have different fathers or different mothers, and so different family constellations are available to take the children. And when we are promoting kinship care as the first placement, sometimes those tough decisions have to be made. Does this sibling go with the father's parents, or does this sibling go with unrelated individuals just so they can be with their siblings? Those are tough calls to make, but in many instances we find that siblings for various reasons cannot be together. And when that happens, then visitation between siblings is very, very critical as well. Often if there's been dysfunction in their family, all they've had are the siblings and that commonality between them. They've borne a lot of experiences together. There's a certain comfort that comes from that. So making sure that it's not just the visitation with the parent and the children, but the siblings themselves. And we really encourage, and we've seen a lot of foster homes really step up to the table that way, and relatives and kinship care meeting together at McDonald's just so the kids have time together. So it doesn't have to be formally all the time with case aides and take their time. Really promoting and asking, can the foster parents get together? Can the kinship care folks get together? So these kids have time together as much as possible. Very, very important to the security of the children to know that they have each other. When you have placement, which is necessary for the safety of the children, you cannot always have siblings together. It's just not always possible, but that should always be the first choice. And the guardian has a perfect role because you represent all the children. Even if they're placed in different places, you represent the children in many instances. And so having a concern about them as a family and making sure that you, again, prick the conscience of the agencies and providers to ensure that these children have time with each other. Sometimes adoptions even take place, and as a guardian ad litem, you would want to make sure that Act 101 is honored and that people understand that even though their children's lives may go forward in a permanent nature apart from one another, they will always need that connectedness and that contact, particularly when they're older and remember that they had a life together. So as a guardian, really, really championing that cause for the children can make the difference between maybe a lifetime of grief and loss and depression, which would not be necessary otherwise. Maybe one of the most understood, I've been a judge for 25 years and I feel badly that I haven't learned about grief and loss until about the last 5 years. And much of what I've learned about grief and loss has come to me through my practices in adult drug court. because my experience there has been that I've seen the damage of unresolved grief and loss in adults. And that's what has clued me in of what a priority it has to be at the front end when children are going through these experiences through the dependency system. So we have science now, we have research, we have the ability to understand grief and loss. And when we don't address it, we create insecure souls, we create people who do not feel connected, people who do not understand themselves what effect grief and loss has had on them, and they continue to just crash and burn, pull themselves up, crash and burn from the unresolved grief. And it is a great disservice for us not to front load at the beginning. And as a guardian ad litem, you have a great opportunity to know children and to know and experience and listen to what they're missing. And they could be missing their teddy bear. They could be missing just the smell of their bedspread at home. It might not have been the greatest bedspread, but it was theirs. And so as a guardian, early on in the case, asking, what does the child have from their past life? Was there anything brought from their home with them, a particular book? And maybe a cup they like to use, and learning that as a guardian, asking the child about that regardless of their age. You might be surprised at what you learn and what could give comfort to this child. And that, just that minimization of grief and loss can make a tremendous difference in how they cope and learn and have success otherwise in school, or maybe even in that foster family. I know that sometimes we hear about bad behavior in a foster family, and we often think the child needs medication, or maybe the child needs a psychiatric or psychological evaluation. But as a guardian, if you can start with the why, and are they dealing with grief and loss first, you might be surprised how much you can ameliorate the situation by simply asking that question and tuning in. Otherwise, we do more harm than good. The most important thing you can do as a guardian ad litem for your child is to believe in them. Believe in them and believe in their family. And believe that every family has strength. You might have to look for it. You might only start with one. And you might only start with progress, not perfection. But believing in the family makes all the difference. You will feel better about your work, and the family will feel better about you. And always remember, when you help the family, you help the child.
GALs, it's nice to be here with you. It's nice to have the opportunity to talk to you about the child welfare system. I'd like to talk to you a little bit about the goal for children who enter the child welfare system. The goal is always reunification. If that is not possible, and the only reason it should not be possible is due to ongoing safety threats, there are other alternatives that you will need to look at. The goal can be changed to adoption, SPLC, or APLA. APLA is strongly discouraged because what that really means is that we have not found permanency for these children. Guardians, whenever a decision has to be made to remove a child from their home and from their family, it should be based solely on a safety threat to that child. When children are removed from their home, there are other options for living arrangements for those children. The first thing to consider is other family and kin. Children need to be kept with the people that they know and with the people that they love. If there is no appropriate placement because the child will not be safe, foster care and group home care can be considered. However, we need to remember we go from least restrictive to more restrictive. The only reason that a child would not be returned to their home is if there was a safety threat to that child. It is important, guardians, that we remember this is not about compliance. It is about safety.
Know your child.
Make sure you talk to your clients.
Don't be satisfied with the first impression of a child.
Don't discount what the child tells you.
Don't talk down to the child.
Develop a relationship with the child.
Make sure that you understand your child's developmental needs.
Know your child.
Understand the context of your child, the family, his community.
Don't interject your personal values on the child or his family.
Always ask why.
Discover the true reason for the child's troubling behaviors.
Know your child.
Obtain and review all reports prior to the hearing.
Come to court prepared.
Don't accept reports at face value. Dig deeper.
Maintain a relationship with the caseworker throughout the progress of your case.
Always question the need for psychotropic medication in children.
Respect the wishes of a child.
Know your child.
Welcome to the world of child welfare. As you embark on your new journey of representing children, I must share with you and remind you that every individual has a fundamental right to raise children. However, under certain circumstances, the state can and will come in. At that time, the child's removed. A child's world is torn apart. The child's confused, frightened, distraught. The child's then brought to court. The first person the child's going to get in contact with is you. As new guardian ad litems, or in Philadelphia as we say, child advocate, I need you to remember that a child is a precious life worth protecting. Your responsibility is to make sure that we, the judges in the Dependency Court in the Commonwealth of Pennsylvania, are provided with adequate, proper, and sufficient information so that when our signature goes on that order, the right thing is done in pursuit of permanency, safety, health, and well-being for each and every child that stands before us. I ask you, know who your client is. Speak to the child. Make sure you read each and every report that's provided to you. Make sure that you are vigilant in your representation. What I ask of you is to come into the courtroom knowledgeable, prepared, with an open heart. The child you save today will be the futures of tomorrow.